Yes, I don't want to repeat what has already been said about private international law in general, other than to endorse, I think, how Secretary Jean-Michel Aougui began by saying, really asking the question, why should we be interested in this topic? Really, fundamentally, we fly not at the helicopter level, but even one level above that, and say, truly, we have a situation where we have a person A in state B, in state A, we have a person B in state B, and those individuals will enter into a contract, they may get married, they may have a child, then they get divorced, then there are issues of support obligations. You know, what law governs, essentially? What is the legal framework that governs those relationships between those persons, whether that's an individual person or whether that's a legal person? That's really what we're talking about here when it comes to private international law. I think it's just sort of good to take that step backwards or that step above and say, but that's really the issue here, that we're, the kinds of topics that we're addressing, and they've been talked about in various aspects, of course, when it comes to insolvency of that person, that legal person, or whether it comes to support obligations. So in general, that is why member states are interested, because it's their parties, it's their citizens, their residents that are affected by these very issues. And as Jean-Michel was saying, these are issues that matter very much to people on a day-to-day basis and can make such a difference. So when it comes to the Organization of American States, we have had a long history, and in the Charter, the specialized conferences are what have really been the vehicle for working in the field of private international law. So we've had the Conferencia Interamericana de Derecho Internacional Privado, so CD for short. And we've had 6 CDs, and then sort of a half one of CD 7. And those have produced a number of conventions and model laws as well. I didn't produce a list like this, but we do have it on our website. So if you go to the OAS Department of International Law website, you will see our list, and we do also keep a record of what the ratifications are. We do have a few dead bodies on our list as well, so we want to avoid that down the road. So that comes in terms of addressing your question here. How can we collaborate in a better way with other organizations? Because we are very small. Our Secretariat is very small. I've had the benefit and the opportunity and the privilege of working also with UNCITRAL and now back at the OAS. So this is actually one concrete example of perhaps Secretariat collaboration on that level. So we've been looking at ways that we could work together more closely. In the codification and development of new instruments, that's been an area that has traditionally been the most difficult, and it really shouldn't be. And perhaps in the past, because we have not had the kinds of interconnectivity that we have now with communications, it should be much more easy in the future moving forward, that we should be able to capitalize on the role that we have as a regional organization. It's sort of like we are the small nuclear family within the larger extended family. We could look at things in a way that we could support work that's being done at the international levels and have more of an internal debate with our member states. The challenge is really, can we develop instruments moving forward, if we do that address the unique needs of our Western Hemisphere, while at the same time ensuring consistency with developments that are happening at the international level. And the only way that we can do that is really by communication. And so this is really one of the reasons for us coming together and bringing organizations here today, so that we can look at this new chapter moving forward to engage in more collaboration. Another way that we might be able to work more collaboratively together would be in the area of comparative analysis of various international instruments that exist already. And Spiros has mentioned the publication where there has been the evaluation of different kinds of instruments in the area of secure transactions. And we're hoping to be able to take it to the next step, where we now look at the model law, the Inter-American model law on secure transactions, as something that we can include in that kind of an analysis. So that's another area where we have a specific objective of the possibility of collaboration. A third area is in the collection and dissemination of case law, because as important as it is to develop international instruments, as was said by one of the speakers earlier this morning, there's very little point in doing that if then the instrument is going to be interpreted very differently in different regions of the world, in different countries. So UNCITRAL has, of course, this wonderful body called the Case Law on UNCITRAL Texts, where they actually collect and then disseminate case law interpreting these various instruments. And it would be interesting if there's something that we might be able to do and perhaps work together with organizations. I'm not sure whether you have something similar, but it might be an area. Okay. So there's areas where there's possible collaboration there. In a fourth area, I think, where there's a possibility for collaboration is in the next phase now going forward. Because the instruments are only as valuable as they're going to be when they're implemented by member states. And we're now trying to work with member states, and one particular project that we have is in the area of secure transactions, looking at the model law. But we want to be able to do that in a way that benefits the member state. It's not promotion of our model law. It is what is of need to the member state. And so this is an area where we are inviting other organizations to participate in the regional seminars that we are now organizing with member states that are interested in this project, so that we will have an opportunity to examine different instruments, and then the member state is going to be able to undertake reforms that are appropriate to their particular situation, but at the same time help us move forward to regional harmonization and to international harmonization, so that we maintain that consistency moving forward. So that's an area where we see actual potential for collaboration. And we're actually going to have our associate here, Eugenio Brielas, who's going to be talking about the specific project. So if that, does that answer your question? I don't know if you want to comment at that point before I turn it to Eugenio.
Maybe just one quick comment, and I'm talking also under the sort of collective supervision also of SPIROS. I think it's fair to say that there is much more cooperation between the organizations now than there has been 20 years ago. I do remember very specifically one of the first major meetings I attended as a representative of the Hague Conference. I have been with the Hague Conference now for 16 years. Was one of the first meetings on the receivables convention. And at one point there was a discussion on conflict of laws in receivables. And I was there, this young delegate, and presented with this question, and I said something along the lines of, well, this is not that easy. It's delicate, it's difficult. Let's establish a joint working group to look into these issues. And I remember the room looking back, going, where is this coming from? We are not used to these messages of cooperation and let's work together. And the result was that we had a wonderful joint working group where collectively experts from UNCITRAL and the Hague Conference looked into this issue, and then the final result was exported back into the UNCITRAL convention, which now has this chapter on the laws. The three heads of organizations of UNCITRAL, BINIBOR, and the Hague Conference, we meet once a year to coordinate a work program, to exchange views, to see if there is room for synergies and what have you. So there the cooperation exists, it's effective. With the OAS, the cooperation has been taking a different shape, different form, in the sense that our meetings are open to other intergovernmental organizations. They can come as observers. The OAS has come on multiple occasions and has taken an active part in our meetings. Same goes vice versa. But it's maybe less of a institutionalized type of cooperation that we have. And I personally see this meeting as maybe a sort of a catalyst to go there and explore possible ways of a more institutionalized cooperation between organizations. Because I do believe that the organization with a global mandate can establish a general framework, and regional organizations should be in a position to build on that global framework and to go further and have more integration at the regional level, because among a specific region there is more liberty, more freedom to go further than what you can do at the global level. The real challenge is just to make sure that the regional development and the regional regime remains compatible with the global regime. Quite honestly, it has not been such of an issue or problem or challenge in the relationship between the Hague Conference and the Americas, the OAS. It's a bit more of a challenge between the Hague Conference and the European Union. Just because of the political powerhouse that the European Union is, and their decision to also do more and more private international law. But I'm very pleased actually with the more recent developments and cooperation with the European Union and the interaction that we have, which is also reflected by the fact that the European Union is a member of that economy.
I hope you are happy with the information you are getting. Here is my contribution. The principle of coordination and cooperation. Member states should give to the organizations a mandate to do it, and should also ask the organizations to devote resources, for example, for organizing coordination meetings like this, for example, for sending delegates to the meetings of each other's organizations. So it is a matter of not of the will of an abstract organization or secretariat, but an instruction, a concrete instruction of member states. The past. The past, for one or the other reason, that mandate was not always, as Christophe mentioned, always very clear, or if it were clear, the resources were not there. Still, we did what we could under the circumstances, so we took into account the work of the OAS in anti-trust on secure transactions, and there are references throughout our work to the work of the Organization of International States. Latin American states which participated in the preparation of these texts were key participants in our context and provided the coordination at the state level, not so much at the organ, but there was also inter-organizational contacts. And of course we had other organizations like the Inter-American Bar Association or Inter-American Banking Federation. So there were in the past, here or there, regional contacts. Now the future is bright, or brighter, let me put it that way. And I would agree with Jeannette and also with Christophe that we should look at multiple areas and multiple levels. Legislative work, secure transactions was mentioned. It's an obvious example. A state which has adopted the OAS model law with little effort, if any, could say they have adopted also the recommendations of ANSECOM. And we could assist that state to present to the world the message that we have adopted international standards, so we are fine. And also as a message to the World Bank, and we'll be discussing with the World Bank, including its solvency and secure transaction standards of ANSECOM in the World Bank principles, to say to the World Bank, we are okay. Which has, of course, political and practical results. Electronic transferable records. It's an additional point that could be discussed. The electronic warehouse receipts are electronic transferable records. So a potential point of topic of coordination with a working group on electronic commerce. Incorporation of small and medium-sized corporations with a project of joint stock companies. What kind of cooperation? It would be good for us to hear what is the regional experience and the regional knowledge and expertise. It would be good for you to reflect that experience and have your interests covered by an international text, taken into account in international text. There are, here or there you may find that there are conflicts or competitions. There is also a basic joint interest that these texts would be balanced and we represent the interest and the views of all the world to the extent possible. Legislative work, technical assistance, as Jeannette mentioned. We could work together on matters of providing, projects providing technical assistance to states in the field of secure transactions and perhaps other fields. We could start holding seminars. For that, we need first the political mandate of the organizations, member states, and then, of course, we have to act within our limited existing resources. But I have discovered, I've been with UNSCOR for more than 20 years now, that we keep moving the borders of the possible and the impossible. How? By sitting down, analyzing issues with some goodwill, discussing matters which we thought that before the discussion started were impossible. Of course, our work is not perfect. Of course, our work has weaknesses. It's part of life. But within these limits of reality, we can do much more than we ever, and we have done much more than we thought a few years ago. At the end, we should be able to all justify our existence, not by serving ourselves, but by providing service to member states, justifying, of course, the expenditures that member states make or contribute to the budget of all these organizations. That is why you see us here all together, trying to coordinate and cooperate to provide some value to member states.